It's my understanding that much of the work of the D.C. Circuit involves regulatory agency cases and administrative law, and you've obviously thought and written a great deal about those issues, and I think it's fair to suggest that if confirmed that you're going to play a special role in future Supreme Court cases in those areas. I'm interested in the area of administrative law from my chairmanship of a subcommittee here of this committee. Now, I understand you to be an outspoken opponent of the legislative veto. You criticize Congress for, and these are your words, passing laws with strings attached. Now, I personally disagree with your view because I'm opposed to the tremendous amount of legislating done by faceless bureaucrats who aren't elected by anyone. So I'd like to explore the subject of the legislative veto. What if Congress enacts legislative veto legislation that satisfies, one, bicameral passage, and two, the presentment requirements set out in the Constitution? Isn't that about all that's constitutionally required?
Those are the only two problems that were raised against the type of veto that was struck down in Chadha, and I suppose if those two requirements, if those two problems were overcome, the problem would be eliminated. But I'm not sure you'd still call it a legislative veto.
Well, that would then be following upon writings that you've done in the Administrative Law Review Article 70, 1976, the Regulation Magazine, February 81, Regulation Magazine, December 79, in which you cite only those two constitutional imperfections. So your view today then is similar to what you had previously written.
Well, what matters today is not my view of what I previously wrote, but what the Supreme Court subsequently decided. That is, subsequent to what I previously wrote, the Chadha case.
Well, and assume again that...
I think you're presenting to me a situation in which the two defects discussed or identified in Chadha were eliminated. On the basis of Chadha...
assume again that a legislative veto statute then would meet the Chadha test. Don't you agree that a legislative veto serves a virtue in today's age when it's so difficult for Congress to legislate policy statute by statute against a backdrop that we find ourselves in here of constantly changing issues?
Senator, as I told Senator Kennedy, one of the things I've always been concerned about, and my writings show it, is the problem of excessive delegation by Congress to the agencies. It's an awfully hard problem to deal with. To the extent that there is a device that will enable Congress to review more closely the activities of the agency, that is desirable. If there is some way to get proper legislative attention to what the agencies have done by way of implementing earlier statutes.
Yeah. Well, you accept the environment and decide within that environment. I hope that Congress reacts, that we can't anticipate crises, and that I hope you accept that it's unreasonable to expect Congress to do otherwise, and then accept the fact that that's why Congress delegates authority to agency expertise.
No, I understand. I think that's right.
Okay. I think we'd all agree with the Constitution lasting 200 years now, and hopefully for another 200 years, that we have found our founding fathers to be very practical people. I have a hunch that given the range of agencies that we now have today, whether it be FERC or the FCC or the Consumer Product Safety Commission, and you can go on and on, which of course they, writing 200 years ago, could have never dreamed of, that they might find the veto a fair and practical way to deal with the bureaucracy today. Do you disagree with that?
It's conceivable that had they envisioned the kind of a system that would develop, they would have made provision in the Constitution for a legislative veto. Although, as the Supreme Court has said, they didn't. That's what the Supreme Court has said to date.
Well, what the Supreme Court said to date is what
That's
Congress
right.
passed for a legislative veto up until Chadha, that those forms of legislative veto were unconstitutional. You're said to be a free market advocate who favors economic deregulation, and I made reference to the fact that you'd written for Regulation magazine, and you said you had edited it, and that's kind of a gospel of deregulation. I'm not going to ask you to comment on any specific regulation, but can you give me some indication of what factors you consider when faced with a constitutional challenge to economic regulation?
10 minutes.
I don't recall that I've been confronted with a constitutional challenge to economic regulation during the entire time I've sat on the court I'm now sitting on. Frankly, constitutional challenges to economic regulation are pretty rare nowadays. Most of the challenges are on the basis of whether the statute permitted the economic regulation in question. I really wouldn't even know where to begin to grapple with the question you asked. It's I think I'm not sure that I am sure that the experience of my circuit is not different from the experience of most circuits. It's very rare that economic regulation nowadays is challenged on constitutional grounds.
Well, along that, you know, I'll accept
Equal
that.
protection challenges have just not fared very well in the last half century anyway, and that would be the normal source of attack. And
Well, must the regulation be more than simply wrong-headed for it to be overturned? And
oh, absolutely, yes. It'd have to be more than, and the agency's action would have to be more than wrong-headed to be overturned on statutory grounds as well. It can be reasonably wrong-headed, and we'll approve it.
in a case decided last year, Hershey versus FERC, and that was involving the Equal Access to Justice Act, you took the occasion to comment on what role legislative history and committee reports should play in judicial interpretation. And I hope it's fair for me to conclude that you showed a great deal of hostility towards committee reports in that writing. You wrote in a concurring opinion, and I quote, "I think it's time for courts to become concerned about the fact that routine deference to the detail of committee reports and the predictable expansion in detail which routine deference has produced are converting a system of judicial construction into a system of committee staff prescription." Now, that's pretty doggone strong language. Let me first ask, how important is legislative history to you?
I think it's a significant factor in interpreting a statute. I've used it in my opinions.
Well, let me ask you, how come you don't repeat the usual answer that we get, that, you know, if you do refer to it, if the statute, the language of the statute itself isn't clear to the judges interpreting?
Well, I guess I didn't repeat that because
So
everybody...
obvious?
It's so obvious, and
But you accept the obvious.
number one, it's so obvious, and number two, because we normally don't have a lawsuit in front of us if the language of the statute is clear. Almost invariably, the language of the statute is argued to mean one thing by one side, another thing by another side, and where that's the case, legislative history.
Are you
is
going to be
effective.
then turning to the legislative history then that frequently, as you say, that the statute is hardly ever clear?
I will use what seems to me reliable legislative history when it's available to be used. The trouble in legislative history, Senator, is figuring out what's reliable and what isn't reliable. That's the trouble with it.
Well, I want to tell you, as one who served in Congress for 12 years, legislative history is very important to those of us here who want further detailed expression of that legislative intent, you're not suggesting that for committee reports to have any meaning, that they must be actually written rather than merely approved by members of Congress? Are you suggesting that?
Well, I don't want to pin myself down to a commitment to use any particular type of legislative history or not to use any particular type of legislative history. I'm just saying I will not exclude it as a basis for my decisions, as I have not in the past. And that it depends on what the snippet of legislative history is and how genuine a representation of the congressional intent it seems to be.
Well, let me be a little more specific. When you decide a case and look to the legislative history to help you, is it meaningless for a committee report to suggest that a court has misinterpreted an earlier statute and have that statement be meaningful to you?
In the Hershey case that you're talking about, it seems so to me because the statute hadn't been changed. The statute was reenacted unchanged, although it would have been easy to clarify the provision that was ambiguous and that had been the subject of the earlier court decision. What happened, it seemed to me, as best I could read the legislative history, was that the body as a whole had no intent concerning that earlier decision, probably didn't even know of that earlier decision. But the committee at most, and perhaps only the committee staff for all one knows, did have views about that opinion and put it into the committee report. But it is, of course, the view of the whole Congress that counts. Now, if the act had been amended in some respect, and if this statement in the committee report were an explanation of why that amendment which came out of the committee was suggested, then it would have had more weight. But here, the statute was enacted entirely unamended, and the statement in the committee report seemed to me almost a dictum. It had nothing to do with the bill that was on the floor.
Well, I think the facts are that there were a number of changes made in successive reauthorizations to that legislation.
No, but I said unamended in the respect that had been the source of ambiguity, which was the subject of the prior court decision. Yes, the act was amended in other respects, but there was no amendment to which this particular language in the committee report had any relevance.
Would it be improper to ratify, so as to speak, a correct court decision by Congress stating that in the committee report?
Can Congress ratify a court decision?
Well, what I'm saying,
Congress can only act, Senator, Congress does not act in committee reports. I will say that flat out. Congress acts by passing a law. The only value of a committee report
I'm speaking to the point of Congress accepting a view of a court decision and expressing that in the committee report, and then that being legislative history towards what Congress intended to some extent. And I'm talking about a correct interpretation.
I think that the statement in the committee report would have to be an explanation of something that Congress did in the statute. If it were an explanation of something that Congress did in the statute, and it shows that what Congress did in the statute was based upon thus and such an interpretation of a prior, or an acceptance of a prior opinion, then it would be of value.
Well, suppose Congress sees two different court interpretations of the same statute, and Congress says this is the one that we intended.
In the law? No problem.
In the committee report, as a statement of congressional intent.
I wouldn't think that was of any relevance unless Congress had done something in the law of which that statement in the committee report was an explanation.
Suppose it's Congress's judgment that what we said 5-10 years ago is exactly what we intended, and we still intend to say it. It doesn't need a change in the statute, and we're saying with two court decisions with opposing views of that this is the one we like. What's wrong with that as a judgment by Congress of telling the courts how we want the statute interpreted in the future time?
If I could know that that's what the whole Congress meant, there'd be no problem about that at all. But I don't know it when all I see is a single committee report. I can't tell that that's what the whole Congress meant, just from looking at a single committee report, where Congress has taken no action on the face of its statute to which that report is somehow tied, which that report explains, where it's just passing a law that, and the committee that happens to have jurisdiction over that area makes a comment.
Well, obviously, we're talking about a committee report that would follow legislative reauthorization or some other form of congressional enactment for that specific Congress by which the report came.
Yeah, but my only point, Senator, is I don't think that gives the committee the right to opine on all matters pertaining to that law, not to those matters which the committee is bringing before the full Congress. And mind you, all I'm seeking to do, and it's a problem for any judge using legislative history, is to try to figure out what the intent of the Congress is, and to what extent this expression, whether it be on the floor by a single senator, that's a problem sometimes too, or whether it be in a committee report, whether that genuinely represents what the whole body intended, so that we're sure we're not disenfranchising the Congress and getting you as a member of the Senate committed to a position which in fact you knew nothing about and would disagree with.
Okay. Well, the reason why I ask these questions is that I think I detect something in your writings, whether it's on the Graham-Rudman, the legislative veto, or this example I just gave. I sense a very critical view of how Congress tries to get things done. Can you address this concern, whether or not you think I'm being too sensitive about it?
Now, honestly, Senator, I have no criticism whatever about the way Congress tries to get things done. You can get things done any way you like, and that's your affair. And I understand the problems that you confront in trying to get it done. The problems that you tried to grapple with a legislative veto, and the kind of problems you're referring to that can be handled by committee reports.
Your background is primarily academic. You've also had a stint in the executive branch, but you never served in the legislative branch, and of course I'm not suggesting that you should.
I'm sorry I didn't, Senator. I frankly have gotten a good look at the territory of the law. The one slice of life I didn't get a peek at was Hill work, although I dealt with the Hill to some extent when I was in the executive branch.
Okay, I'd like to ask if you think that fact that you haven't served in the legislative branch might explain a lack of deference to the methods of the legislative branch in how we choose to do our job within the political constraints that we have to account for here.
No, I don't think so, Senator, because some of the criticisms I've made about committee reports, for example, have been made by members of the Senate. And you certainly couldn't explain it that way as far as their criticism is concerned.
But there isn't one of those senators that might criticize a specific committee report that takes the same that shows that same lack of respect for committee reports, because they would be involved with committee reports in almost every piece of legislation that comes before them and that they have to vote on. Mr. Chairman, I have no more questions.